final thing is really just to note in relation to land repair earthworks, which is not part of phase 1 but will be part of phase 2, and that work is still, I guess, continuing on that to make that rule a bit more easy for people to use and to continue to aid recovery. So that work is still continuing for phase 2 of this chapter, which will include earthworks.
Sorry. So the earthworks, we've got quite a few issues there at the moment, particularly around asbestos and hydraulic fluid going into the soils. What's the current thinking around that? I personally don't think that's something we can wait for another stage 2. What I want to be satisfied is that we've got sufficient control where people are disturbing the earth to ensure that contaminated soils, to ensure that things like asbestos or hydraulic fluids and oils that are being left are actually remediated or taken away safely. So also in flood zones, and again, I don't quite know what the thinking is, but surely there should be some requirement to maybe raise the land or to do certain things.
Yeah, so your first point about timing, I guess, is one thing that we've been, or the group that's working on this rule has been looking at. The issue, I guess, is if we get the alternative to doing it through the district plan review in phase 2 is to have the minister use his powers under section 27 of the Sierra Act. The problem with that is that they're having an election and breaking for that period, so probably it's just as fast to do it through this process. I think Sarah is still trying to push it through, but they're sort of running out of time to get that to the minister, I think.
No, if I could make a comment, the land contamination part of the land contamination and hazardous substances chapter came to you on Friday, and you discussed there how these matters were going to be dealt with. The actual hazardous substances part, like how we try and stop the land becoming a contaminated site, will be dealt with in phase 2. The Minister and the Mayor, as has been discussed already this morning, are still discussing about a final deadline for any truncated process, but my understanding is that all parties, both the Ministers and the Mayor and the Council, is trying to come to a conclusion of that process so that it can be applied to these priority chapters.
The point I'm making is that by the time we wait for the stage 2, a lot of stuff will have already happened which will have negative outcomes, particularly in terms of earthworks. I mean, we're already seeing it. People in flood zones are having their houses lowered into the flood zone. It makes no sense. It's outrageous, quite frankly, that this is happening in a modern 21st century city and country. So there has to be, we have to deal with this with some
Councillor, I think you're talking about the natural hazards, which is coming to you tomorrow. The issues that you raised,
earthworks,
the one that you just raised, is a part of the natural hazards chapter.
It's an example of why just leaving things isn't working, and I would have thought with the current vulnerability around around flooding, around asbestos, around all the other stuff that's happening in terms of contamination, that earthworks is a pretty important thing to be dealing with.
In terms of flooding, the existing rule in the operative plan that deals with repair of damaged land does control earthworks in the flood management area. It controls it in terms of volume on that site and height above, amount of fill above ground level.
Section 27. There was a section 27
but you
process.
get Skirt doing works, for example, in the Wolfston area, and they're basically leaving the land as low as it was before. It seems like unthinkable. But I don't know if they need a consent. I don't know if, because they're doing earthworks, that they just, and it's a response, that they just bypass all the normal, rational, kind of logical things that you would do to improve it or to do it differently to recognise the increased risk you have post-earthquake, versus just hurrying up, going as quick as you can and not getting consents, not putting back the things that make sense. It's like...
through you, Mr. Chair, it's pretty hard to answer that without knowing the specifics of what exactly they're doing and what are the consents they needed to do it. There's all sorts of possible scenarios that might apply. One is that I don't know, it's reliance on existing use rights. Well, even if there's reliance on existing use rights, generally the Building Act requirements come into play over how high floor levels have to be. If the Building Act requirements haven't come into play over how high floor levels have to be, then the work's being done as an exemption under the Building Act. If it's an exemption under the Building Act, we can't do anything through the district plan review process to influence that. That's about how the Building Act operates. But that's just, Councillor, that's just one example of the type of factual situation you may be describing. I'm not sure whether that one applies or not. So it's pretty hard for us in the context of a district plan review to answer questions about what's happening under the Building Act and the existing plan.
And indeed, this is why there are 8 priority chapters. This is why we are seeking with the ministers a truncated process to try and get these new rules in place to replace those parts of the operative plan which are currently, guiding resource consents.
Yeah, there was a second question there about control of earthworks on contaminated land. The chapter proposed for the district plan review for contaminated land has objectives and policies but no rules, and that's because there's the National Environmental Standard for contaminated land, and it's that National Environmental Standard that sets out what has to happen if land is contaminated, what investigations need to be done, what the council's discretion is as consent authority, what sort of thing it needs to think about in terms of conditions. So it's that National Environmental Standard that addresses any issues to do with the work of contamination.
So we'll deal with that tomorrow. The final question I have in terms of this, or the 2 questions, there's a lot of changes around comprehensive development mechanisms, etc., etc. Just help us understand that. And then the other thing that has previously been raised, which we need to look at, and I think we do it through subdivisions, is private right-of-ways. Are we limiting the ability for people to have private right-of-ways? And if not, how can we do that?
The first question in relation to the comprehensive development is around the new neighbourhood zone. And I wasn't the writer of that chapter, and so we're hoping to have Scott Blair here on Thursday to talk to you about those issues. I don't know enough about them to comment. So, in terms of private right-of-ways, no, we're not looking to prevent people from doing that. Do you have a...
So the question then is, how do we do that? Because we've seen that they've really, they aren't working. They're creating all sorts of problems post-earthquake in terms of infrastructure repair. They're all tied up with very legalistic body corporate structures and really unclear rules around maintenance. So right-of-ways and gated communities is something this plan should be doing something about, in my view. And so how can we do that? And I think this was raised, you'll recall, right at the start.
Yeah, I think it is quite an issue. There's a number of lanes, particularly in your ward, Ione, that suffered quite a lot of damage in the earthquake, and the argument of who was liable for repair and could council come and do this bit or that bit in body corporates, it's not 100% clear, so it's an area that does need to tidy up.
It's also things like people can't get waste collection, they can't...
Yeah, waste collection's all got to go out to the main street. They can't be collected from the lane.
They're just a nightmare. I mean, I don't know why we ever agreed to let them happen in the first place, but any rational assessment of them probably show they haven't really worked. And it's pretty good to have clarity around who owns what, so that we have less confusion and a better outcome.
I think in terms of whether they're useful things to have in the plan, private right-of-ways, the advice to me is that would be that they are useful things to actually have. I know there's issues with repair and maintenance of them, as you said, but I think in terms of getting good urban design outcomes, sometimes it is useful to have those and the ability to include those. If you think about some of the new greenfields areas where a row of townhouses, for example, might front a street, they often have a laneway behind them for vehicle access, and that can be a private right-of-way or a laneway. and that prevents, you know, double garages and not much else facing the street where most people would be viewing those properties from, or perhaps facing an open space area.
To be
So
fair,
you can
this
get
is something
access
that
from-
needs to be covered in phase 2, sorry Andrew, and you'll notice that this is a part chapter, subdivision development and earthworks, so that would come through in phase 2.
With regards to private right-of-ways, etc., when you're buying a property, if you're down a private lane, your lawyer, your legal team should have identified whether it is public land, as in the driveway, or if it's part of a body corporate as a private lane. So I'm not quite sure where the confusion is, because, I mean, if you've got a private driveway, when you've bought the property, you would be a member of a body corporate. Therefore, the council has no responsibility with regards to that. If it's a public driveway, as in owned by the council, then I think that's fairly clear. But I'm not quite sure where we're going with this, because if people haven't done due diligence, is that our responsibility? But that comes down to the owner, not the. That's not the council's.
You're talking two different things. So there's what they call the leg-in, which is a section at the back, and then it's just a shared access way. There are some situations we have on the Port Hills and some of the areas there where some people have created whole subdivisions with one access, and that whole access is all private land and private ownership.
And you get situations where people don't own it but have right of way of it and all that. But that is the individual's responsibility to sort out. The council can't be held responsible for if you're renting or if you've bought a property and you've got right of way. You know, there has to be a limit to, and it has to be very clear. No, that has to be an agreement or an understanding, or however that's worked with that private property. If it's a private property and there's an issue with it, how is it the council's responsibility? I'm not quite, I mean, it's... Well, shouldn't it be that we sort out the confusion with before it's built?
The landowner has got an obligation. You know, it's as simple as that. You know, we might as well say, oh, it's difficult creating rates. Why do we charge it? Shit. Why do we even have a count? You know, there's a million things. It's just life. If someone buys a property and they're part of a body corporate, the owner has obligations. It's up to them. They can sort that out. They can take them to court, but they're obligated to pay it, and it's not actually our problem. It's really simple.
Right, Glenn.
No, it's simple for us because the simple fact is, if you've got property owners that have got shared access or a right of way or they're part of a body corporate, that is their issue. But it's not necessarily for us as a council to involve ourselves in. I think you're absolutely right in what you're saying, Tim.
But Yanni, are you coming from the point where is there an opportunity, do you think, that we can clarify it before it starts so we can tidy up our district plan? And I don't know.
What benefit private right-of-ways actually give to the city, what I see is they cause a lot of headaches unnecessarily that we could probably prevent by being proactive in the space.
Look, I think, can we just draw this one to a close? I think there's a message down there that's been understood, and we maybe just need a bit of clarity on a couple of points.
Yeah, I think
move to Glenn.
Thank you. Probably this debate is a microcosm of what actually happens up these private rights of way and what I've experienced. But is it the council's responsibility through the district plan not to sort these arguments out, but actually to provide clarity in the first place over this mix of public and private?
Through you, Mr. Chair, it is the council's responsibility through the district plan to identify the resource management issues in relation to the difference between a public road and a private right-of-way. Now, if there is a resource management issue there that's appropriate for the council to deal with, then it is appropriate for the council to turn your mind to what are the provisions you want in the district plan and why you want them. So if there's an issue there that you see happening in the community, a resource management issue, then it's perfectly appropriate to turn your minds to how that can be dealt with in decision-making on subdivision consent applications. Because through that decision-making process on a subdivision consent application, there can be conditions or plans approved that show roads rather than private right-of-ways.
And I think it's that clarity which would most help out.
We have heard the concerns, taken a note of them. That's correct. However, that's not a part of this particular phase of chapters.
Maintenance on them, on private right-of-ways?
I think in terms, perhaps I can assist, there's a few things we've done in terms of the issue. One, we've moved subdivision from a controlled activity to a restricted discretionary, so we actually have some discretion in terms of things like right-of-ways and how they're managed. We've got subdivision design standards, and that will be looking at, particularly in relation to the new neighbourhoods area, which are your new subdivision areas. Basically, the urban design approach to that is to not have back sections, that you actually have sections which front streets. So when you look at design of subdivision now, you won't find these long leg-in sections that have about 4 or 5 properties coming off them. So that's also happening. The third thing that's probably happening as well is council practice, and this is throughout New Zealand, is that previously the older rights-of-way were created with very limited right-of-way easements or documentation going with them. The rights-of-ways which are created nowadays require you to have legal documents going with them that set out exactly the responsibilities for people with those. Now, we can't deal with historical rights-of-way because that's what they are. We can't go back and revisit those. But the new rights-of-way standards come with a whole set of requirements as to who's responsible for what, and those are set out in the easements that go with the right-of-way. So quite a different situation than previously.
So what happens with old rights-of-way? They just have to exist as they did?
Exactly, and it's, the council encounters this through a number of things, whether it's retaining walls on the Port Hills that have been damaged and who's responsible for the retaining wall over rights-of-way. They're there at the moment, and there's nothing very much you can do about those existing rights-of-way.
Thank you. Right, moving forward.